I'm a bad mode, gotta keep it tight. Hold my baby squid, keep him out of sight. Talking about my life, government stay away. Hefty drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. Mama to my baby, protecting with my no government intrusion. I control my life.
Hey guys, welcome back to the channel. So tonight we are talking Carly Gregg. This was the stream I was trying to do the other day when we were so rudely interrupted. But on that note, before we get started, so that we do not get interrupted and I don't go on a tangent, I was in Spawn's chat a little while ago and he said something about hearing a rumor from somebody, I really don't know who, that I can't take a punch. One, I don't know how that comes up. But secondly, we about to dispel that fucking shit right now. This is 2014. I'm pretty positive that I can take a punch. Just a thought. Just we're gonna make this my new background. But yeah. So there's that. We're just gonna let this sink in for a second because one, if you say I can't take a punch, that sounds like a threat to me. And two, I've taken a punch from some professional fighters, and I've punched back. So, yeah. We're just gonna, I love making people look stupid. It's so easy to do. So, we are going to talk about Carly Gregg. And I'm trying to find all the documents that I had as I was doing some other stuff beforehand. I'm making a new music video because Shizzy made me a new song. Yeah. It's going to be a good one. I just have to make a video, and I'm thinking that I'm going to include that picture in my new video. Just something I thought of. You can tell me what you think of that. Baby Squid's asleep, and Mr. Squid's still awake, so I'm trying to be somewhat quiet. I have the door closed, but I'm trying not to be as No, it's an AI video. Well, it's an AI song. But I like it. I can play you guys the song right now if you want to hear it. And then before we get into these Carly Gregg, or we can just get into it and I can debut the video, which I think is what I'll do. I'm just I was uninspired for the video until that. So, well, this is the song. Let's see. Shizzy titled it Mama Bear. It has no video right now. So.
She was quiet night, but real. always at dawn, but there's a storm will come once stood. When shadows danced around her child, she showed them what a strong heart could. Through the dark when troubles crept, whispered threats and ghostly sneers, she turned into a force of fire, burning through her deepest fears. In the dark when troubles crept, whispered threats and ghostly sneers, she turned into a force of fire, burning through her deepest fears. Oh, when you push her too far, she's a wild card, playing rough. Mess with love that's deep and true, you'll find out soft ain't always enough.
I love this. Shizzy did such a good job.
Those who thought they'd take her down underestimated fire's glow. She forged her strength in firmest flames. When stakes are high, she'll never bow. Judgment came like wolves at night, but a roar it echoed wide. She fought with every ounce she had, defending what she holds inside. Oh, when you push her too far, she's a wild card, playing rough. Mess with love that's deep and true, you'll find out soft ain't always enough. Those who thought they'd take her down.
So that's just part of it. It's 4 minutes long. I'm not gonna play the whole thing. Um, I know Ong Hung Hero. It's when you make a song for everything, it gets a little not annoying, but like meh, another song. But I only have 2, and one is just a video by itself, or 3. I have the Sarah Boone one, but I need a new intro video, and I'm thinking that's gonna be it. Um, because I've needed a new intro video for a while, so it's like that one kind of fits. Um, it yeah, because 'cause I'm just getting sick of the one I have right now, so it was kinda perfect that he made that, because 'cause I'm like, I was feeling a lull in creativity, if you know what I mean? So, I understand that they're overdone, but, like, I don't do them very often. I haven't done one in, well, it's they are kinda funny. It's when they're, like, forever long, and it's when they're used as intros and outros, it's like, it's cool with me. It's like when it's every, part of the thing, then I'm like, but I need a new intro video. I was feeling kinda I was getting kinda bored with mine, but I couldn't think of what I wanted to do, and then, it came to me. Well, Shizzy made it for me, so it didn't come to me. It it came to somebody else, and then they sent it to me. So, I am going to open up the studio. There we go. And then we are going to open up these documents. In FlashFan, I'm trying to find them. So if I had them all open and then I closed them all uh when my internet was being funky. So yeah. Um oh, come on. I think I skipped past them. How did I skip past them? Hey. You know what? Like, at first it bothered me, and then I'm like, why do I care about what 2 Thunder Cows and a wannabe Johnny Cochran think? Like, it's like, Bruce, you have enough to worry about with all the lawsuits that are coming your way and the lawsuit that you are going to lose for your client. Like, because the more he talks, just like Gingras, God help me, Just like Gingras, the more they talk, the more they make their client look bad. Like, most of the lawyers that I've talked to don't talk about active cases. Like, you keep your mouth shut on active cases because at the end of the day, your case is not a PR case. No matter what the public thinks, good or bad, doesn't matter. It's like, yeah, yeah, never don't replace stupid with stupid. It's just like, whatever. Like, um, oh, I'm trying to go back to where you sent me all the stuff, and I must have like moved or moved all the links because I usually have them like starred and ready to go, and then I just didn't. Um, yeah, all that shit doesn't mean shit in a court of law. Like, you no, like no, that's not how this shit works. Um, do 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 do. And I'm so sorry. I had all these documents open and I closed them all when my internet was being stupid and like now I'm getting like even that news article that we were looking before. There we go. Ugh. So we have articles. Hey Peachy, how are you? So we read the article the other day about the prosecution requesting a new trial in the Rankin County fiasco that is Carly Gregg. Um, Flash fan, you're amazing. You're amazing. But because we are so rudely interrupted, I don't know if we ever finished it because I kind of pulled the chat over and went ape shit. So we are going to read this article and then we are going to read the article of the response. Oh, I tagged YouTube this morning and said they in on Twitter and said they sucked because they're like, you can block them. That's all they ever say is, well, you can block them. Well, here's the thing about blocking people. Just I did. What's he up to today? Um, it you can block people all you want, but if they still want to be dicks, they're gonna be a dick. Find a way around it. And blocking what they have to say doesn't block the actions in real life that the threats that they're making. It doesn't stop that. Um, so blocking them on here really doesn't do much. Plus, I really don't like to block people because um I like to watch the shit show ensue and I like to watch people make fools of themselves, but um no, this is not. That is Savannah, Georgia. That is a current trial. This was the trial that I covered in September. The 14-year-old who is convicted, I no longer have to say alleged, of unaliving her mother, Ashley Smylie, and attempting to unalive her stepfather. And the she was found guilty. She was sentenced to life in prison without parole. She is 14 or 15 now. So we are so and this article is super small. I can't make it any bigger. I couldn't the other day and I can't now. So Carly Gregg asked for new trial. Carly Gregg filed a motion for a new trial yesterday in Rankin County Circuit Court, and this is out of Mississippi. A jury convicted her last week of first-degree murder and attempted murder and sentenced her to life in prison without parole. Gregg was 14 years old when she killed her mother and shot her stepfather on March 19th. The motion also asked Circuit Judge Dewey Arthur, one of the best in the business, to throw out the verdict in the alternative. Attorney Bridget Todd filed a motion on behalf of Gregg. Todd argued Gregg was not tried by a jury of her peers. Gregg is 15 years old. Jurors must be at least 21 years old to serve on a jury. However, Mississippi law allows minors such as Gregg to be certified as adults if they commit certain crimes. You play stupid games, you win stupid prizes. Ugh. Sorry. Todd poised that these two fundamentally opposing legal standards cannot be rectified. This contradiction in law constitutes a new trial, or in the alternative, a judgment notwithstanding the verdict. The state admitted there was an absence of motive. Since it does not support the verdict, Gregg must get a new trial, or a JNOV, which I'm not sure what that is. Juvenile, something juvenile, I'm assuming. Carly's father, Kevin Gregg, was interviewed by WLBT on September 26th. Kevin allegedly said in the unaired portion of the interview that Carly was placed in equestrian therapy as a child due to experiencing auditory hallucinations, hearing voices. The new information supports Dr. Clark's diagnosis of an unspecified schizophrenic disorder. Since the new information would likely lead to a new trial, Gregg is entitled to a new trial. Gregg timely disclosed her witness list to the state 13 days prior to the trial on September 3rd. The discovery was due on August 20th, per Judge Arthur's order. The state did not produce its witness list until September 8th. Todd complained the court found Gregg engaged in a willful discovery violation in order to gain a tactical advantage at trial. The court struck 2 defense witnesses. Todd calls the radical sanction improper and a gross violation of Gregg's Sixth Amendment rights. Todd argues that her client should not be placed in an adult prison or have to wait for the appeals court to adjudicate this issue. I'm torn on that one. Forensic psychologist Dr. Jason Pickett testified as an expert witness for the prosecution at trial. Todd said in his testimony was improper, unethical, and highly prejudicial at trial when he commented on Gregg's mental condition. He has no experience dealing with children. That issue again. Like, she always brought up the fact that he has no issue dealing with or experience dealing with children. He's testified in like 100 cases. And thus his testimony was prejudicial against Carly Gregg. See, you've never testified with about a child before, so you're prejudiced? That makes freaking no sense. Like, from a legal perspective or a fucking English perspective, that makes no sense. The court erred in granting all of the state's pretrial, trial, and post-trial motions. They did not, while denying all of the same motions by the defense. Well, Miss Todd, perhaps you should have filed your motions on time instead of past the deadlines. God, I like this guy. The sentence violates Gregg's 8th and 14th Amendment rights. The motion does not cite any case law or statutes. Here's the here we go. And I'm glad that this article has this, considering Mississippi, you have to pay to get documents. So, Carly Madison Gregg motioned for a new trial, or in the alternative, judgment notwithstanding the verdict. Comes now to the defendant, Carly Madison Gregg, herein referred to as Carly or defendant, by and through her attorneys of record, and files this, her motion for a new trial, or in the alternative, judgment notwithstanding the verdict, and in support thereof, would show unto the court the following facts and matters to wit. Following her criminal trial, Carly was convicted of first-degree murder, attempted murder, and tampering with evidence. The jury announced their verdict on Friday, September 20th, 24. 2. Pursuant to Rule 25.1 of the Mississippi Rules of Criminal Procedure, Carly moves this court for a new trial. 3. Specifically, a new trial is required in this matter based on the following factors. A. It is in the interest of justice. This is an opinion piece. This looks like it was written by, like, a middle school, like, English teacher. Really, Uncle Buck? Like, specifically, a new trial is required in this matter based on the following factors. It's in the interest of justice. B, the verdict is contrary to the weight of the evidence presented at trial. That's not what the jury thought. C, new evidence and material has recently been discovered, which probably would produce a different result at a new trial. And by reasonable diligence, such evidence could not have been discovered sooner. They had every opportunity to talk to her dad. They just didn't. Like, can anybody explain to me that watched this trial why the defense never mentioned Carly's dad? Carly's biological dad never called him as a witness. They could have, they didn't. That sounds like ineffective counsel, um, not that you couldn't figure this out sooner. Oh my god. Please, Flash fan, please no. Please no. Ugh. D. Witnesses necessary to establish Carly's defense were improperly excluded from testifying at the trial. No, they weren't. Witnesses were improperly restricted in the testimony they could provide in Carly's defense. And F. Carly did not receive a fair and impartial trial. What evidence? What evidence do you have for that? This sounds like something Amber Heard wrote. The new trial is in the interest of justice for several reasons. Carly was not tried by a jury of her peers. Carly was 15 years old when her trial commenced on September 16th, 24. Mississippi requires a person to be age 21 and older to serve on a jury, despite the fact that a person can be legally registered to vote at 18. Their juror age prerequisite is founded on the understanding that with age comes maturity. Mississippi believes that a person 21 or older possesses the maturity necessary to make decisions about the life of another, which they did. Uh, how about you don't commit adult crimes if you don't want adults to my god, this is fucking ridiculous. Oh, like, I used to be, like, anti-state, and now I'm like, the state in some of these cases, the state is having to deal with some pretty incompetent, inept, incompetent, idiotic, um, ill-prepared defense attorneys. Thinking of any other I word I can come up with. Yeah, they claimed his issues proved she was mentally ill, but they never actually spoke to him. They never actually brought him in as a witness. There's no records of them having a conversation with him. Mm. However, Mississippi also holds that a 14, 15-year-old possesses the maturity necessary to make decisions about plea offers, understands the nature of alleged offenses, comprehend the nature of the charges against them. You took somebody else's life. It's really not that hard to comprehend. Yeah, I'm just saying. Effectively participate in their defense at trial and face the same lifelong sentences of an adult. However, these two fundamentally opposing legal standards cannot be rectified. This contradiction in law constitutes a new trial, or in the alternative, a judgment notwithstanding the verdict. The undisputed evidence at the trial of Carly's mental illness, loving relationship with her mother and stepfather, absence of prior criminal charges. You don't need prior bad acts to do something stupid. Absence of prior violence, good school record, doesn't matter. Straight A students can still be criminals. Just saying. Just saying. Support the victim's testimony that Carly was not in her right mind and did not recognize him at the time of the offense, and the state's admission to an absence of motive to commit the alleged crimes and do not support the verdict or sentence in this case. No, the motive is her mom was angry with her and she turned something that would have been a 2-week grounding into a permanent situation. Like, hey, mom, like, mom, how many times did I get in trouble when I was little and do stupid crap? You found cigarettes, stuff like that, and you were pissed, but like, you grounded me. You were pissed, you grounded me, you got over it, and we all moved on. Did I do more stupid shit? Yeah, but, like, you don't make permanent decisions for a temporary problem. Jesus. Like, and if you really wanna be, like, super bad about it, like, she was 14, she was almost 15. You don't have that much longer to go before you never have to speak to your parents again. So, like, at most, she had 4 years of crap before it was like, "I can do what I want when I want." Ugh, and you don't need a motive to that's the misconception. You don't need a motive to prove somebody unalive somebody else. Motive is not required, as long as you have facts. Motive is not required. On Wednesday, September 26, 24, a reporter for Fox 40 WLBT informed the defense counsel that Kevin Gregg, Carly's biological father, had given an interview, part of which would be aired later that night. In an unaired portion of his interview, Kevin Gregg disclosed that Carly was placed in an equestrian therapy as a young child due to experiencing auditory hallucinations. Defense counsel contacted the attorney representing Ashley Smylie in her civil proceedings against Kevin Gregg regarding documentation or information that might be helpful in Carly's criminal trial. However, no such identification or documentation was identified or produced. Shocker. 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 Uh, Kevin Gregg refused to cooperate in Carly's defense, refused to talk to the state, refused to talk to the mental health professionals evaluating Carly. Interesting, because that's what a subpoena is for. You don't get a fucking choice. Just saying. And refused to come to any pretrial hearings or a single day of Carly's criminal trial. Okay, that has nothing to do with what he said. Just thought. Ay, ay, ay. This new information supports Dr. Clark's diagnosis of unspecified schizophrenic disorder and is likely to lead to a different result at a new trial. As such, Carly is entitled to a new trial. She ain't entitled to shit. The sense of entitlement here. Just saying. Carly timely disclosed her witness list to the state pursuant to the timeline established by Mississippi Rules of Criminal Procedure. No, you didn't. Carly produced her witness list to the state on September 3rd, 2024, 13 days prior to trial. Carly's witness list was comprised of 9 total witnesses, and one witness would only testify at a pretrial hearing. All of the witnesses listed were known to the state prior to the production of the witness list. The state's witness list, MEC 234, was produced to the defendant on September 8, 24, 8 days prior to trial. It was comprised of 55 witnesses. The state's amended witness list was produced to the defendant September 9th, 24, 7 days prior to the trial. It was comprised of 57 witnesses. However, it was the defendant the court found had engaged in a willful discovery violation. Yes, because the discovery was due August 20th. And the state, not to defend the state, but the state can't comprise a witness list unless they know what they're fighting against. And as the defendant, you have to go first. Just a thought. Oy. I mean, just a thought. Just a thought. However, it was the defendant the court found had engaged in a willful discovery violation, motivated by the desire to gain a tactical advantage at trial. So, for those of you who didn't actually watch the trial, um, the discovery deadline was August 20th. The state did or the, defense did not even hire their expert until, I wanna say September 3rd. I wanna say September 3rd. So, if if the defense doesn't produce the expert, it's very hard for the state to produce. I think it was August 20th because I believe the original deadline was in July, but then the judge being graceful extended it. I think it was August 20th. It was originally July 26th, and then it got pushed out, I think, if I'm remembering correctly. Um, but their they didn't hire their witness or their star expert witness, Dr. Clark, until after the discovery deadline. So it's interesting that they're they're saying, "Well, the state did this." Yeah, the state did that because they don't know what expert to hire or look at if they don't know what your expert is going to try to prove. And if you don't submit your expert report, they don't know what they have to fight against. I mean, like, I'm just a common sense thing for me. Yeah, and she also turned down a 40-year plea deal that would drop it would drop the other 2 charges completely, and it would be 40 years for first-degree murder. But she said no. So, as a result, the court struck 2 of the defense witnesses and restricted the testimony of the remaining defense witnesses. The 2 witnesses struck by the court were both immediate family members of the defendant, both of whom had spoken to law enforcement as early as March 19th, 24 and March 22nd, 24. Both witnesses were present during at least one of law enforcement's searches of the crime scene. The state never contacted either witness, never requested a continuance, and interviewed several of the defense's remaining witnesses. Moreover, this case was tried less than 4 months following the indictment and 6 months after the incident occurred. There was sufficient time for either the defense or the state to gain a tactical advantage at trial. Important trial evidence was still being produced in response to a subpoena the weeks leading up to the trial. I mean, but there's no case law. There's no uh, the court's finding of a willful discovery violation is not supported by Mississippi case law. Prove it. With what case law? With what case law? Not supported by any case law. Like, how do you know? What cases did you look at that didn't work? Like, I'm obviously not a lawyer, but you have to put something in there to prove your point. Like, I don't know. The radical sanction imposed by the court was constitutes a proofread, lady, proofread. Did one of her paralegals write this and she didn't bother to look at it before she submitted it to the court? A gross violation of Carly's Sixth Amendment rights and due process and merits a reversal on appeal. Carly should not be placed in an adult prison or have to wait for the year or longer that it will take for the appellate courts to address this issue. Justice delayed is justice denied. I kind of don't disagree with her on that point because Carly's 15. Right now, she's in solitary, and a 15-year-old in solitary, that's just not gonna do her any good. Like, I know she's gonna be in prison for the rest of her life, but I have a very difficult time, and I kn there and there's in lies the issue, because I know she's not appropriate for a juvenile detention facility because she's a convicted murderer. However, I believe it's slightly unethical to keep her in keep her in solitary just because she's a child. It's one of those mm, it's one of those difficult, there's no right answer thing. But can you put a 15-year-old out in Gen Pop? There's an ethical problem with that too. Like, it's yeah. Due to the extensive pretrial media coverage, there really wasn't extensive pretrial media coverage because a lot of people didn't know this trial was going on until it started, or like 3 or 4 days before. That's when people started covering it. Unlike me, I've been covering it since July. But, what oh, I don't really know anybody else that was covering it before it happened. There would be an occasional news article, and the media was in each like, the media was in each hearing, but that doesn't mean it was extensively covered. Because I didn't even see it pop up on Law and Crime until I searched for it, or a Flash fan sent it to me, which means he searched for it. It's not something that popped up like, you know, Samsonite Sarah. Uh, Due to the extensive pretrial media coverage, the improper statements made by the state during the live streamed pretrial hearings, I'm hoping there are exhibits to prove this, because what improper statements, that's a opinion until you can prove it. Everything's an opinion until you can back it up with receipts. Take note, people. Improper testimony from Rebecca Carly's counselor regarding a book Carly wished to read. Carly was denied a fair and improper. What the hell? Rebecca Kirk's testimony regarding Carly's comment about wishing to read a Russian name, Crime and Punishment, was not disclosed to an oral statement by the state in their amended witness. This testimony was of no importance in the facts in Carly's case and was elicited for the sole purpose of prejudicing the jury. How is wanting to read a book prejudice to the jury? Like, there are certain books I've wanted to read just for the sake of knowing what was going through the person's head who wrote them. For example, yeah, I don't want to get yeeted off of YouTube, but a German book written by a certain German person, well, Austrian person that, you know, acted German, you know, I've wanted to read that book, not because I like the person, but because I want to understand what was going through the effing mind of that person when they did the horrible things they did. Yeah, and just because you like true crime doesn't make you, it's like saying someone who likes true crime is a criminal. It's like, no, they just find things fascinating, like me. I like psychology. I like to know why people do what they do. I have a book about the Luftwaffe. That doesn't mean I want to be a German World War II soldier. It just so happens that I like aviation and like war, or history of war. Yeah, I'll pass on that, Flash Ann. Thanks though. Um, I have a really okay, Flash fan. We're gonna pull the chat over for a second. Um, it's not that I don't want to talk to Melanie Little, but right now I don't know a single lawyer. I don't know a single lawyer right now on in the YouTube universe that I trust. or that I think is actually well, except for vices. Vices. I'm having a very difficult time with, like and Danny On. Vices and Danny On are I've gotta say are the only 2 lawyers that I think aren't full of shit. So, like and be it I don't watch every lawyer on Imma try not to say anything that's gonna get me yeeted off YouTube. Y yeah, Andrea, but I don't really watch Andrea, so I mean, I do, but I don't. Like, one of the well, she doesn't really post a lot, so no. Yeah, we're just gonna Flash fan, we'll talk later. We'll talk later. Um, oh boy, where was I? This fact is highlighted by the state's erroneous belief that Mrs. Kirk was concerned about Carly reading this book as the title was underlined in her records, without realizing that it was simply grammatically proper to underline doo-doo-doo-doo, grammatically proper to underline titles of novels. This testimony was elicited during the state's rebuttal and was one of the last statements the jury heard prior to beginning their deliberations. Ugh. Yeah, I know she's in Delphi, but that's because there's very limited coverage. The judge for Delphi is not allowing any media or very limited media. This is according to Mo. Mo did a 45-minute video today on Delphi and updates and stuff that I was able to watch about 2/3 of. But it's interesting the state making efforts to keep that trial a secret. So, Andrea, Flash fan, you're fine. I ain't mad at you. I just had to laugh at that comment. Um, Dr. Pickett's testimony regarding his diagnosis slash undiagnosis of Kevin Gregg, Carly's biological father, was improper, unethical, and highly prejudicial at trial. Not really, because the defense was trying to use the fact that her father had a mental illness to say that it was genetic. So why is she saying that the prosecution bringing it up his mental health when that was half the defense's argument? It doesn't make any sense to me. But anyway, pursuant to the ethical guidelines established by the American Psychiatric Association, the Goldwater Rule prohibits and enjoins psychiatrists from offering opinions about the mental health of someone they have not personally examined. That's not exactly true. You can offer an opinion based on medical records, but you cannot, if I'm remembering this correctly, but you cannot diagnose. There is a difference between diagnosing and offering an opinion on a medical record. There is a complete difference. He never said, I believe he had this. He said, based on what I read, he never said he was diagnosing. And in fact, I might be remembering and take everything like I say with a don't quote me, but I believe he had mentioned I can't diagnose him or I'm not diagnosing him. I could be wrong about that, but I think I remember that expert. He was a very his expert was or the state's expert was very thorough, but it was very, very long. So I was kind of fading. But I do have a playlist with all my Carly Gregg stuff. Ugh. So did you of someone they have not personally examined. Dr. Pickett was the last witness called during the state's rebuttal, and his was the last testimony the jury heard prior to beginning their deliberations. That was on purpose. Yeah, yeah, exactly. Very careful to say this is just my opinion. I'm not their therapist, so I can't, I can't diagnose. They can offer their opinion, they just can't diagnose. It's kind of the same with not just not just psychiatrists, but a general practitioner can't go by looking at her, she has this and this and this. It was like, no, I think she might want to get that checked out because it looks like she might have. There's two different things. But, you know, like I'm not gonna lie, based on working with like patients for years, when I see somebody walking down the street and I'm like, I see them walking with an AFO or like an a brace of any kind, I'm like, I wonder what happened to them. I wonder is that from an accident based on the way they're walking and the way their arm swings? Did they have a like my brain goes completely like, but that's not me diagnosing, that's me using my knowledge to infer what might have happened. There's a big difference. Big difference. And the state put Dr. Pickett on last for this whole purpose of being the last thing they heard. That was intentional. But that's gamesmanship. That's not prejudicial. Here we go again. Dr. Pickett did not possess the proper expertise necessary to testify in this matter due to his inexperience with evaluating children and adolescents. She also needs Grammarly on this one because it's adolescence, like ENT not adolescence, the time frame. Just a grammar Yahtzee here. With forensic evaluations in general, and his inadequate background in child and adolescent. That's the word she should have used up here. Just saying. Psychiatry. Carly is entitled to a new trial based on this unfair and improper trial she received. The court erred in refusing the defendant's request to instruct the jury to return a verdict if of not guilty made at the close of the state's evidence and the close of the evidence presented by the defendant, and erred in denying the defendant's request for preemptory instruction. The court erred by denying the defendant's proposed jury instructions by failing to provide the jury a definition of reasonable doubt. You don't have to provide them a definition of reasonable doubt. You don't have to. That's not an error. That's life. The court erred in granting all of the state's pretrial, trial, and post-trial motions, which the court granted. That's false because the judge ruled against the state in one instance and said, "I hope you appeal this to the state." Flashman, you remember that one? He literally said, "I don't think I'm right in doing this, but I'm, you know, ruling against the state." And he told the state, "I hoped they appealed it." I'm like, so that right there is an outright lie. She lied. I need that Greg Wooden she lied defend or button. Yeah, remember that Flash fan? Like I don't remember exactly what they were arguing, but the judge was very torn on it and said, "I think I'm wrong in this ruling, but there's no case law in this area. I hope you appeal it so that we get some case law." So he did rule against the state. So she's a liar, which I'm not really surprised from her. So, likewise, the court erred in overruling each of the defendant's pretrial, trial, and post-trial motions, which the court denied. That's also a lie because if they ruled against the state, they ruled for you. So, there's one paragraph, two sentences, two lies. The court erred in sustaining all of the state's objections, which the court sustained. Sh- Are we sure she passed seventh grade English class? Because this is like, with the size of the text and the double spacing, this shouldn't be this hard to read. The court erred in sustaining all of the state's objections, which the court sustained. Likewise, the court erred in overruling all the defendant's objections, which the court overruled. That makes no sense. Flash fan, don't insult Sarah Boone like that. Like, I thought I was reading it wrong for a second. That's why I had to go back, because I'm like, I had to read it again because it just didn't make any sense to me. The interests of justice require that this court exercise its supervisory powers to grant the defendant a new trial and/or judgment of acquittal or judgment notwithstanding the verdict. Well, you're not going to get acquitted. You took somebody's life. The sentence of the defendant is excessive, not supported by the evidence, and is disproportionate to the sentences imposed on other similarly, English, situated defendants, and violates the 8th and 14th Amendments to the Constitution and corresponding sections of the Mississippi Constitution. You need to put, okay, I'm sorry, I'm judging her writing, but you make a public filing, you put yourself out there, you're destined to get scrutinized by the public. If I were a judge, I would want a footnote stating what sections of the Mississippi Constitution that we violated, because I'm pretty sure the Mississippi Constitution is very large and detailed. And please put that you corresponding what the Mississippi Constitution has 14 amendments, or what, like, please, somebody please, like, help me out here. Like 8 and 14 amendments. All right, put what sections of the Mississippi Constitution that the 8th and 14th amendments talk about and are, like, put your paragraph. Cumulative error in the trial requires a new trial. 19. Other grounds to be assigned once the transcript is available and upon the hearing hereon. Holy vey. Yeah. 26th of September, Carly Madison Gregg, defendant, Bridget Todd. Oy. I'm just, yeah. And then the certificate of service, blah, 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 blah. Damn, that was hard to read. Yeah, I tend to always, Flash fan, I tend to always say grounds, even though I probably shouldn't. Um, so this is one thing that I've decided that is quite entertaining. For some of these, for some of these articles, they have comments at the bottom. Let's read the comments, shall we? Anonymous. Todd argued Gregg was not tried by a jury of her peers. Gregg is 15 years old. Juries must be at least 21 years old to serve on a jury. Blah, blah, blah. Sometimes you wonder, other times you know, why are you reading a novel legal argument? Anonymous. Why? I was found guilty. I want a new trial. Taking bets on how quickly it gets denied. Isn't getting this appeal denied the first step on its way to the U.S. Supreme Court? Exploit completed. Was ineffective assistance of counsel listed? The motion does not cite any case law or statutes. Save a tree. These comments are freaking awesome. If she's legally too young to consent to sex, then she'd never be tried as an adult, period. How do you reconcile her mental inability to consent to one and not the other? Well, see, I understand where that person is trying to go, but at the same time, you unalived somebody, your mother. You unalive the person who brought you into this world. They should also argue that the judge threw out the motion to use an insanity defense because Carly smoked marijuana. I don't know about you, but I'm not aware of anyone going insane from smoking marijuana. The judge was just one of these Rankin County Bible thumpers that hates weed. Well, he might be. Like, oh, au contraire. You obviously haven't watched the peer-reviewed documentary Reefer Madness. Full disclosure, it was peer-reviewed by the highly acclaimed scientists Drs. Cheech and Chong. Oh my God. Like, oh. I can't. I just can't. Like, mm. We have all been waiting on Todd to show her cards. Go fishes for preschoolers. Point five fingers back at you, Bridget. This is on you in camp. That is, yeah. Oh boy. Anyway, let's go to the state's response. Prosecutors respond to defense's request for a new trial. Rankin County prosecutors are firing back. Days after attorney Carly Gregg asked the court for a new trial in her case, last month the 15-year-old was sentenced to life in prison without the possibility of parole for the shooting unaliving of her mother, Ashley Smylie, and the shooting of her stepfather, Heath. About a week after her sentencing, attorneys for Gregg filed a motion for a new trial, arguing in part that the new evidence had been discovered, in particular, unaired portion of a WLBT interview with Gregg's biological father, Kevin Gregg. WLBT has since released the transcript of that interview, refuting the defense attorney's Bridget Todd's claims, a fact that's referenced by prosecutors in their 48-page motion asking the court to deny the request. Let's see. Let's just get straight to it. And we will try. Yeah, this court, I'm going to skip through the BS that's in every court filing because yeah. However, should this honorable court consider the defendant's motion to be proper, the state would show the following in opposition to the defendant's motion for a new trial, or in the alternative, judgment notwithstanding the verdict. On September 2024, a Rankin County jury found the defendant guilty of murder, attempted murder, and tampering with physical evidence. The defendant was represented by attorneys with a combined almost 40 years of legal experience in Mississippi. Those attorneys made multiple decisions during the trial based on their trial experience. Their trial strategy was to admit to the jurors that the defendant committed the crimes, but to argue that she was insane at the time of the crimes. Regarding trial strategy, this court has held that the conduct of trial counsel is measured towards the view that he has wide latitudinal discretion in effectuating reasonable representation on behalf of his client, and that the decisions made at trial are strategic. Nicholas v. State. This court rarely second-guesses trial counsels regarding matters of trial strategy. Renfro v. State. Oh, look. Cites. Case law. Not liking the outcome of a trial is not grounds for a new trial. Mississippi Rules of Criminal Procedure 25.1b outlines the grounds for a new trial. This is what she should have done, but she can't because she had no leg to stand on. 1, if required in the interest of justice. 2, if the verdict is contrary to law or the weight of the evidence. 3, if new and material evidence has recently been discovered which probably would produce a different result at a new trial, and by reasonable diligence such evidence could not have been discovered sooner. 4, if the jury has received any evidence, papers, or documents not authorized by the court, or the court has admitted illegal testimony or excluded competent and legal testimony. 5, if the jurors, after retiring to deliberate on the verdict, separated without leave of court. 6, if the court has misdirected the jury in a material matter of law or has failed to instruct the jury on all questions of laws necessary for their guidance. Or 7, if for any other reason the defendant has not received a fair and impartial trial. The Rankin County jury got the verdict correct, and there were no errors by the court that adversely affected the defendant. She is not entitled to relief under Mississippi Rule of Criminal Procedures 25.1. Standard for motion for new trial. A motion for new trial is based on the weight of the evidence and will be disturbed only when the verdict is so contrary to the overwhelming weight of the evidence that to allow it to stand would sanction an unconscionable injustice. Herring v. State. Such motion is within the discretion of the court. The court takes, quote, the evidence in a light most favorable to the verdict. Nelson v. State. Citing to Jones v. State. Ordering a new trial should be invoked only in exceptional cases in which the evidence preponderates heavily against the verdict. Anderson v. State. So much case law. So much case law. Applying the standard to the case at bar, the defendant's motion for a new trial should be denied. The defense opted for the trial strategy of telling the jurors this is not a case of whodunit. They cannot now claim that the weight of the evidence resulting in the defendant's conviction for crime serves as unconscionable injustice. Standard for motions notwithstanding the verdict, directed verdict, and preemptory instructions. In a criminal proceeding, motions for a directed verdict and a JNOV challenge the legal sufficiency of the evidence supporting the guilty verdict. Williams v. State. Croft v. State. Moyes v. State. Motions for a directed verdict and judgment notwithstanding the verdict challenge the legal sufficiency of evidence, and the standard of review for the directed verdict and judgment notwithstanding the verdict are identical. Croft v. State. A motion for directed verdict challenges the sufficiency of evidence, and the critical inquiry is whether the evidence shows beyond a reasonable doubt that the accused committed the act charged and that he did so under circumstances that every element of the offense existed. In judging the sufficiency of the evidence, the trial judge is required to accept as true all evidence that is favorable to the state, including reasonable inferences that may be drawn therefrom, and to disregard evidence favorable to the defendant. Jackson v. State and Weaver v. State. Challenges to the sufficiency of evidence require a determination of whether, after viewing the evidence in light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Bush v. State, Sharon v. State. Ugh. If the evidence was sufficient to establish guilt beyond a reasonable doubt and support a guilty verdict, then the denial of the motion for a directed verdict is to be affirmed. Shelton v. State. Nichols v. State. The standard of review for preemptory instructions and directed verdicts are the same. Williams v. State. In passing upon a request for preemptory instruction, all evidence introduced by the state is to be accepted as true, together with any reasonable inferences that can be drawn from the evidence, and if sufficient evidence to support a verdict of guilt exists, the request for preemptory instruction is to be overruled. Mississippi law is clear on the subject of preemptory instructions in criminal cases. Preemptory instructions should be refused if there is enough evidence to support a verdict. This court will reverse only when reasonable and fair-minded jurors could only find the accused not guilty. Strickland v. State. Yeah, Judge Arthur's probably pissed. Like, I know I'd be annoyed. I'm annoyed just reading that. Like, I am thoroughly annoyed just reading that. So, I wish this wasn't 48 pages, but she did her homework. She did her research. She's got case law to back up her opinions. Like, standard regarding insanity. The McNaughton test for determining insanity is whether the accused knew right from wrong at the time the act was committed. Woodham v. State. Citing Russell v. State. Specifically, the court has held that prove insanity under McNaughton, it must be proven that at the time of the act, the accused was laboring under such defective reason from disease of the mind as, 1, not to know the nature and quality of the act he was doing, or 2, if he did know it, that he did not know that what he was doing was wrong. Woodham quoting Roundtree v. State. The determination of the defendant's sanity under the McNaughton rule is within the province of the jury, and the jury has discretion to accept or reject expert and lay testimony on the subject. Easley v. State, citing Woodham v. State. Russell v. State, a jury's finding on a defendant's sanity will not be reversed if it's supported by substantial evidence. Woodham, citing Davis v. State. We have held that in insanity defense cases, perhaps more than any other, a jury's verdict ought to be given great respect and deference. Sanders v. State. Applying the standard, the jury's verdict and determination of the defendant's sanity should be accepted as it is supported by the substantial evidence. As such, the defendant's motion for a new trial for the jury's verdict is to be set aside and should be denied. The defendant's argument about not having a jury of her peers is improper and lacks merit. The defendant argues that she was not tried by a jury of her peers. She fails to cite any authority for this argument. The argument is without merit and not supported by the law. In our system of justice, every person charged with the crime is entitled to receive a fair trial before an impartial jury of his peers. U.S. Constitution, Amendment 6. Despite the defendant's assertion that a jury of her peers would someone of a similar age, neither the U.S. Constitution nor the Mississippi Constitution require that a jury of defendant's peers must be of the same or similar age. In fact, our courts have previously held that age is not a protected class in juries. More importantly, the defendant failed to object to the jury panel at any time during the trial. Oh, interesting. I never thought of that. Our appellate courts have repeatedly held that a failure to object contemporaneously at trial forfeits an issue on appeal, Potts v. State. More specifically, a failure to object to the jury's composition before it is impaneled waives any right to complain thereafter, see Myers v. State. The attorney's decisions regarding the final composition of the jury should be determined to be matters of trial strategies, see Smith v. State. The applicable amendment to the U.S. Constitution regarding a fair and impartial jury is Amendment 6. It reads, in all criminal... I'm not going to read the 6th Amendment. You want to read it, you read it. Nothing in this amendment entitles the defendant to a jury made up of individuals who are a similar age. The Mississippi Constitution, Article 3, Section 26. See, that's what Bridget could have easily put in her motion, and she did not. Outlines that a defendant is entitled to a fair trial and impartial jury. However, it lacks any language about it being a jury of the defendant's, quote, peers. It says in all criminal prosecutions, the accused shall have the right to be heard by himself or counsel or both to demand the nature and cause of the accusation, to be confronted by the witnesses against him, to have compulsory for obtaining witnesses in his favor, and in all prosecutions by indictment or information, a speedy and public trial by an impartial jury of the county where the offense was committed, and he shall not be compelled to give evidence against himself. Mississippi Constitution, Article 3, Section 26. The Mississippi Supreme Court has held that age is a well-supported race-neutral reason for preemptory strike. HAS Electrical Contractors, Inc. versus Hemphill Construction Company. Johnson v. State, citing Harper v. State, Stewart v. State, Simon v. State, Lockett v. State. Mississippi Code annotated Section 13-5-1 outlines who are competent jurors. It states every citizen not under the age of 21 years who is either qualified elector or is resident freeholder of the county for more than 1 year is able to read and write and has not been convicted of an infamous crime. That's a very interesting way of putting that. Or the unlawful sale of intoxicating liquors within a period of 5 years and who is not a common gambler or habitual drunkard. This is Mississippi. Is a competent juror. No person who is or has been within 12 months of the overseer of a public road nor contractor shall, however, be competent to serve as a grand juror. The lack of any such qualifications on the part of one or more jurors shall not, however, vitae an indictment or verdict. Moreover, this is where I need Zach to be my reading person. Moreover, no talesman or tales juror shall be qualified who has served as such talesman or tales juror in the last preceding 2 years, and no juror shall serve on any jury who has served as such for the last preceding 2 years. No juror shall serve who has a case of his own pending in that court, provided there are sufficient qualified jurors in the district and for trial at that term. Oh my goodness. That is Mississippi, all right. Mississippi Code 13-5.1. The defendant has not shown that any of the individual jurors or jury panel as a whole failed to be qualified under Mississippi Code. Mississippi Code annotated section 13.5-2 outlines the public policy behind a jury being selected at random from qualified citizens. It outlines the protected classes of individuals, but fails to include any mentions of age. 13-5-2 says it's the policy of the state that all persons selected for jury service be selected at random from a fair cross-section of the population of the area served by the court, and that all qualified citizens have the opportunity in accordance with this chapter to be considered for jury service in the state and an obligation to serve as jurors when summoned for that purpose. A citizen shall not be excluded from jury service in the state on account of race, color, religion, sex, national origin, or economic status. Oh my goodness. The jury in this matter was made up of qualified electors from Rankin County, Mississippi. No one was excluded based upon race, color, religion, sex, national origin, or economic status. I think we're going to have to read part of this at another time because this is going to take forever. So we will go to where she finds the next paragraph or next heading, and we'll stop there and we'll read the rest of it later because we're only on page 9 and I'm tired. Our courts have long allowed for the legislature to determine juror qualifications. State v. Hall. That's a lot of pages. Yes, it is, Flashman. The court held that the power to prescribe the qualifications for jurors rests with the legislature and that it has the power to make reasonable classifications. The right to a jury of one's peers does not entitle him to a jury which includes convicted felons or bootleggers. And the legislature has a right to impose reasonable qualifications for jurors when such qualifications do not violate the constitutional rights of the accused person to be tried by an impartial jury. Shows v. State. No error was committed by this court in qualifying the jury as required by statute, which did not include 15-year-olds. More importantly, the defendant, through the trial strategy, selected jurors and failed to make any objections at trial about these individuals or jury panel as a whole. She is now barred from making this claim. This claim also fails under Mississippi law. All right. This next section is kind of short. Defendant's argument that motive is required is not supported in law or reason. This is what I was saying. Despite the law not including motive as an element of murder, attempted murder, or tampering with physical evidence, the defendant makes the claim that an absence of motive to commit the alleged crime does not support the verdict or sentence in this case. Therefore, the matter calls for a new trial, or in the alternative, a judgment notwithstanding the verdict. This argument defies logic and is completely contrary to the law, which says the state is not required to prove motive. Proof of motive is not essential to a conviction for a felonious homicide. Barnett v. State, Swanson v. State, Roberts v. State, Clark v. State, Wilson v. State. Prior to trial, the state submitted jury instructions with the elements of each crime: murder, attempted murder, tampering with physical evidence. See jury instructions given by the court to the jury. The defendant failed to object to those elements instructions, and they were given to the jury. Our appellate courts have repeatedly held that a failure to object contemporaneously at trial forfeits an issue on appeal. Potts v. State. Motive is not included in any of the elements for the crimes the defendant was found guilty. As such, the defendant's argument about a lack of motive is without merit. Like, Catherine is angry. And Jude, thank you for the $2 super chat. Not much, but something. I appreciate you. Ugh. Especially like the people who have backed me up in the last 2 weeks. Or 3 days. Really love you guys now. I mean, I loved you before, but I really love you now. All right, I think that is page 10. we are going to call it a night because it starts to get in the McNaughton rule, and we will read the other 38 pages at a later date. Probably Sunday. I don't know. I appreciate you. And I know Tug and Megan are live, Spawn Trooper is live, Shizzy is live. So I appreciate those of you who struggled through these motions with me, because I'm sorry, Bridget's motion wasn't that long, but like with the no case law, grammatical errors, the way it was formatted was just it just made it a hard read. Plus, she had no actual points, and the points she was trying to make, a layperson could even know that those points were complete BS. Um, so it she's grasping at straws. Like I yeah, I'm live, but everybody else that is live too is, after the stream, I'm going to sleep too because it is family day tomorrow. Um, Originally, I was going to stream opening statements tomorrow morning in the Sarah Boone trial. They start at 9, but I think I'm just going to do a recap on Saturday. Either Friday night or Saturday, probably Saturday, because not a lot of people stream on Saturday. Um, so it'll be kind of a I don't have to worry about other people like that I actually want to watch. Because it's not that I don't wanna stream when other people are streaming, but those are streamers that I really like to watch too. So and I like to participate in their chats. So, it's one of those things of, like, not only am I not gonna get the viewership and look at it from the petty side, I'm not gonna get the viewership because 'cause they're watching, other streams, but I wanna watch those streams too and participate in those chats because they're fun. I appreciate you, and thanks for, looking for Baby Squid's shoe. I appreciate it. So, mom fail story of the day, CPS worthy. We went to run a couple errands today, sign up for a different internet, get rid of this Xfinity crap because it's expensive and it's not working very good. And we decided to go to Walmart after because if there is no bananas in this house, my little one will throw a hissy fit because she will grab your hand, walk you to the pantry, get lifted up, and look at the pantry. And if there is no bananas, she is not a happy camper. So I went to the store and I bought bananas and some other things. Well, we get out to the car. I'm like, I swear everything was normal when we were checking out. We get to the car and she only has one shoe. And I carried her and all the groceries. I didn't take the cart out to the car because I'm like, I'm just not doing this. We're just like, I'm running late. I'm just grabbing her and the three or four bags of groceries. And like, flash fan, I hate bananas. I think they're disgusting. But it's her favorite food. If we don't have strawberries and bananas in this house, like I swear she'd turn into a banana if I let her. I can't have her let her have too many because you know what bananas do to you. Um, but good lord, if we don't have a banana in this house, it's she's gonna walk over there and she's not gonna see them, and she's gonna keep saying no to things, and if she doesn't see them, then she'll cry. So bananas it is. But we get out to the car and she only has one shoe, and I don't have the time to get her put the stuff in the car and walk all the way back because it's Walmart and I park in the back of the parking lot because people in that parking lot drive like it's, the Indy 500. Um, so I can't go, but I know that when my mom gets done doing her thing, she's going to Walmart. So I'm like, this is where we were. We had it here. We didn't have it here. Can you look for it? So my mom went to Walmart and is looking for her granddaughter's shoe. Not 2 shoes, just 1. Mom fail story of the day. The bright side is we only had, like, 1, maybe 2 weeks of wearing those shoes before she was gonna outgrow them. So that was probably gonna be the last one of the last times she wore those shoes anyway, and being the ever prepping person that I am, I have the same shoes in the next size up anyway. It's just funny that, like, I pride myself on the fact that I've never lost her clothing anywhere, and I lost a shoe today. And I'm not sure if it came off when I was taking her out of the cart or, like, she kicked it off. It and I don't know. Like, so, yeah. But I appreciate you looking for her shoe. At least ooh, she hasn't done that. But I also have a a screen on her window to shade her from the sun, so she can't roll down the window. But, I'm sure that'll change in the next couple years. But yeah, that's my mom fail story of the day. It's CPS worthy. I'm gonna start doing that. Like, do a mom fail story of the day because there's always one thing where it's like that you could have done better. That you gave it your best effort and it just wasn't good enough. Okay, story time. I always used to lose my mittens. This wasn't just when I was a kid. I got this really nice pair of gloves and this little mitt and this scarf when I was living up north. And all of a sudden I'm like, I can't find it. I can't find the little thing in your hand. Look, they had gloves, but they also had like a little mitt or a little muff that went over from your palm to your wrist so that, you didn't get that gap because that always sucks, when you have your jacket goes up. And I'm like, I can't find one of them. Can't find one of them. And it snowed and it snowed and all of a sudden when the snow thawed, I'm walking the dogs, I was dog sitting, and I find it in the neighbor's driveway. How the heck did I lose it? And it ended up frozen, and I couldn't not only was it dirty, but I was like, "Okay, now I'm just gonna look like an idiot in front of their garage because I lived in a condo type thing, so it was in front of their garage, and it's frozen to the ground. So it had snowed, and when the snow melted and then froze again, it became a giant ice block. And I'm like, so not only did I lose mittens as a child, but I lose that stuff as an adult too. Because I was like 32 at the time. So like this wasn't and it was my favorite things too. Like it was my favorite, like I love the style of them. And I can't maybe that's how they ended up there in the first place, but then they froze into the ground. And it was only one. It was not both of them, it was just one. So it was like, what was I doing where it fell off? Did I have it in my pocket and it fell out? I don't know. It was just it was like made me so sad. Made me so sad. But yeah, I think I might do a mom fail of the day since, people have threatened to call CPS on me. Let's give them something to call CPS about. She lost her daughter's shoe in the store. She's such a horrible mother. She's on YouTube right now when her daughter's asleep. Oh my god, her daughter was on her iPad today playing a learning game while she was streaming on YouTube. She's such a horrible I can't keep a straight face. Should I do that? Just make a like, I should do it? Like, I'll give the trolls I'll give the trolls some material. And that's the thing too that I wanna talk to Bubbles about. Bubbles made that comment over on 2 fucktards and a dipshit. Um, he made that comment like she called the cops because someone was trolling. No, I filed a police report not because the people were trolling me, because I don't really care if you talk about me. But when you make a threat to call CPS and you endanger the safety of my family and the peace of my family because you're mad at me for something that I don't even know what the yeah, that's the problem because a threat, an online threat in Georgia is illegal according to Georgia law. So it's not the trolling, it's not the name calling, it's the threat. Have a nice night. On that note, yes, that's cyberbullying, and it's very illegal in Georgia. So that's why I called. You heard it here first. My mother thinks Bubbles is an idiot. All right, on that happy note, guys, we will finish this up probably Saturday morning. I'm not sure. It all depends on the family schedule, and I am not, but with all the, talking I've been doing lately on not only my streams, but other people's, and then, I'm allergic to pine, and they came and picked up a lot of the debris today that's been laying on everybody's, like, by everybody's driveways from the storm, and all the movement of the pine straw and the pine like, the branches and all of that being kicked up into the air. My allergies are going a little batshit crazy right now. Um, because it's there's always replay crew, and I'm sure we'll discuss other things. Yeah. Um, or, we might actually do it next week because I wanna make that music video, and I kinda wanna do it live because it's kind of more fun to do it when y'all are helping me 'cause other I stay on task a little bit better. Um, yeah, thanks, mom. I'm allergic to pine trees. So they literally went through with, I wanna say 4 or 5 trucks, um, just and a not a bulldozer, a bucket truck or a bucket. Oh, I'm so knowing heavy equipment is not my strong suit right now, but they went through and, picked up a lot of a lot of the debris, and so and people had some pretty large trees down that you saw. So all of that dander and stuff kicked up into the air. Plus it was only, ugh, 60 degrees today. So it was kind of chilly too. So that combined with the fact that it was the first dry day, I just think I'm really like I have my gallon of water. So ugh, I have my gallon of water because my it's so dry. Like this is what y'all people up north deal with all the time. You have it super warm or like it's warm, but it's not humid. So when it gets dry in the wintertime, it like my lips are going dry, my skin is dry, my throat is dry. So it's like, but thanks, Tim. I appreciate your concern. Um, I will should be fine in a couple of days. We'll see. Plus reading, legal documents is um I'm gonna take some of my allergy medication. I take enough crap on a daily basis that like I don't like to take any medication that I don't have to. So I don't take my my allergy medication on a daily basis. I only take it when I need it, and I haven't taken it in like a month. So that's probably part of my problem too. Mm. But anyway, y'all have a great night. Um, let's see who yeah, 48 pages is a lot. And I'm not even gonna lie, like reading Bridget's um reading Bridget's motion was fucking annoying. Like I wanted to stop halfway through because I'm like, this is bullshit. Like, I really need a stream deck, and, I really need I really need to, I really, really, really need to, have buttons because it's buttons are my, would help me tremendously, especially with the personality, because I wanna be like, "Bullshit," but there's a button for that. Dramatic readings to me are I don't have that change in voices that some other people have that I just can't. Um, let's see. Who should we go to? There's only 6 of us here, but thanks, Jude. She's, in bed, and I believe Mr. Squid is either gaming or in bed too. Let's go to Shizzy. He's watching Sarah Boone, the infamous hearing from today. All right, y'all have a great night. I will see you on the next one. Remember, screw the haters, and if you don't take care of yourself, you can't take care of anybody else. Bye, guys.